Please proceed. We are recording. Welcome, ladies and gentlemen, to the Ethics Commission regular meeting of the LFUCG, August 6th, 2019. We've got a long agenda, and so we'll try to move this along as quickly as we can. We're going to start off with new business. We've got the ethics tip line reports. And for that one, I will entertain a motion to go into closed session.
Move to go into closed session pursuant to KRS 61.810, 1F, for the purpose of discussing the anonymous tip line complaint as it might lead to the discipline or dismissal of an employee or council member.
Seconded. All in favor say aye.
Aye.
Aye. Opposed? Ladies and gentlemen, we're going to go into closed session to handle a tip line matter. If y'all would walk into the hallway, please. Report, we spoke with the individual against whom the tip line report was made. After a discussion with him and consultation among the ethics commissioners, we determined that there was not an ethics code violation, and that will be reflected in the ethics code, or excuse me, the tip line report that comes out next. Next on our agenda is an advisory opinion request, AO 2019-3. Christopher Dent, Mr. Dent, could you come forward, please?
Mr. Dent, we also need, before proceeding any further, on the copy that I have, it did not check yes or no as to whether or not the confidentiality of the opinion was being waived.
It can be disclosed to everyone.
Okay. Okay, we'll take that as a waiver of confidentiality.
I think I should have checked yes on it. The way it was worded, I was wanted to make sure I checked the right one, so I left it.
Mr. Dent, we got you covered.
Thank you.
Please have a seat. Thank you. Mr. Dent, we have your request for the advisory opinion. Could you explain basically what you're here for?
I was an employee of LFUCG for about 7 years, worked in the Division of Water Quality, and I was the Stormwater Quality Incentive Grant Program Administrator at that time, which typically means that I ran the Stormwater Incentive Grant Program. In February 1st was my last day with LFUCG, and after I left, I was able to talk with my children's preschool and decided to apply for a Stormwater Incentive Grant with the preschool. After that, we filled out the application. I was listed in there as a secondary contact, and I also have the potential, if they choose to select me for the design of it, to be able to do the engineering work and the design for a rain garden that would go along with that grant application. So as it went through, the process typically goes that the staff in the Division of Water Quality reviews the grants, and the Director of Water Quality provides an opinion to the Water Quality Fees Board. At that time, I received an email from them that they wanted to check where they had gone through the Division of Law, Mr. Michael Cravens with LFUCG, Department of Law, and he said, I believe I left that email with the opinion in there, that he thought that you all would be the people to determine as to whether or not I would be able to be listed on that grant application. Since that time, since I was able to submit all of this, the grant did go through, so the grant is approved to get funding. They are waiting on the approval and going through with the agreement process until they get a finding from you all on that. And if it is found that I am not able to provide services to that, then I was told that the recipient, the Fayette County Cooperative Preschool, would still receive the grant, and then just have to find somebody else on that. So that covers, I think, most of the information that you all have probably seen on that.
So just to clarify, you are not, as of the time of seeking this opinion, an employee or officer of the Lexington Fayette Urban County Government?
That is correct. My last official day was February 1st of 2019.
When was the grant?
The grant application was due May 5th, 2019. And I believe the application documents came out sometime after I left, but before it's usually out. When I was the administrator, we usually tried to get them out end of February, beginning of March.
So you knew about it before you left, that it was going to be available, that there was, that
It's a reoccurring grant funding program that goes on perpetually year after year unless council decides to take the funding away from it.
Were your children in school there when you?
Yes, my children have been in the preschool since 2012 or 2013. I believe 2013, I believe is when they started there. My oldest, and my youngest is going to be attending this fall as well.
Any other questions? So that we can discuss the ethics opinion, I will entertain another motion to go into closed session.
Can I
Yes, sir.
interject for just a second? I don't necessarily want this tied to the opinion, but I was approached Friday of last week, and I'm not sure. Another engineer or a landscape architect approached me to possibly do some additional engineering work for two grants that have gone through when I was actually a grant administrator. Would like, if it's okay with the board, to provide a little bit of information on that and see if I can get an opinion on that one as well, or do I need to go back through the process?
So probably not comfortable giving an advisory opinion
No.
based upon that.
Okay.
A double advisory opinion, exactly.
Okay, gotcha. I just wanted to, so I'll refill out the paperwork and I'll probably
If you wouldn't mind, yes, sir.
Okay, sounds good. Sorry to interject on that.
So moved as entering into closed session.
Motion to close section, go into closed session. Is there a second?
Second.
There's a second. All in favor, aye.
Aye.
Opposed?
Move that we come out of closed session. Do I have a second?
Do we have a second?
Second.
All in favor?
Aye.
Opposed? We're out of closed session. Mr. Dent, we have considered your request. And unfortunately, given the time of 1 year from when you left the employment with LFUCG and the department that you were working in, there's a provision, Section 2511, about post-employment restrictions that you have.
Okay,
And it says basically that you are not to appear or practice before the agency for compensation, practice for compensation from the agency that you worked for.
okay.
Given the fact that you were instrumental in doing the application, having your name as the second, et cetera, you could not do the work under the grant for compensation.
Okay,
You could do it for free,
gotcha.
and this shouldn't affect the preschool getting the grant.
Correct.
But at least for 1 year, you should not be appearing before the agency that you left.
Okay. And
What we'll do is we'll do up a written report that we
Okay.
will approve the draft at the next meeting, which should be in a month.
Okay.
And we'll get a copy of that to you, sir.
Okay. Sorry, I had a question for you and I was going to make. So I cannot be compensated for any work through that division, but I could do work as long as it's
Oh, you're
not.
going to do all the work. You're just not going to be paid.
Gotcha.
The specific restriction, the section reads, "No salaried officer or employee shall appear or practice for compensation before the governor of the office in which he served." That's the 1 year restriction. And obviously, the point of that is to provide some sort of cooling off period after somebody leaves
Okay.
the LFUCG. And so we discussed and found that because your business was intending to perform that work, then because they have the potential financial incentive, that's where the issue about compensation comes into play.
Gotcha. And that was under 25
25-11 is the
of the
code or the Ethics Act,
Code
which
of
is section
Ordinances.
25 of the Code of Ordinances.
section 25. Okay.
Any other questions?
I do want to, because I think your question is now, and I don't want to speak for the commission, obviously, but this is limited to your request for an
Correct.
opinion. So,
Yes.
if the facts were different, perhaps, if you weren't involved in the application process,
Mhm.
the answer might be different, I guess, is what I'm saying. I don't know that, we haven't discussed it or anything, but our opinion is limited to the facts as presented.
No,
They
no, that's
kinda
fine.
have to be, so if you want additional advice in terms of what else you might be able to do in the
Okay.
field, then we'd be happy to weigh in, of course. But,
Okay.
Yeah.
It was our determination that the grant process, as you described the application, it seemed to us to be too close to appearances or to
Okay.
appearing to conclude otherwise.
Thank you very much for your opinion.
You're welcome.
Anything else from me?
No, sir.
Thank you all.
Thank you.
Look with that rain face.
Okay, next on our agenda, we've got advisory opinion 2019-4. Steve Gahifer, and I apologize if I mispronounced your name.
That's okay. If the commission would like, if y'all want to go and handle a lot of the police officers, and probably almost everybody else is here, please go ahead and do that. I'm one person and there's 15 of them, so.
We might be able to handle this one very quickly, sir.
Okay.
I appreciate your offer, and I'm sure that they do too, sir.
Yes,
But
sir.
we might be able to get rid of this one quickly.
Okay.
Could you please explain to us what you've come to us with?
So, my name is Steve Gahafer, and I work in the Division of Code Enforcement as a nuisance control officer. Recently, my wife and I, who's also a police officer, have wanted to buy some rental property. This first came up because her aunt and uncle were going to be moving up here from Memphis and truly could not afford to buy a house. And we thought we could afford to buy a house and we could give them a decent rate on their rent. We can make some money and kind of everybody's happy. That's how it kind of first came up. I've never really wanted to own rental property at all. It's especially with the part of it I deal with at work. It's not something I want to spend 30 hours a week doing. So, but we've thought since then, well, we wouldn't mind maybe owning 2 or 3 houses that we could get some income off of. Mainly looking at houses in like $125,000 to $175,000 range, which typically are houses that code enforcement does not deal with. Most of the houses we deal with are in the lower economic section of town. Not all of them, but as a general rule. So I don't want to look at houses that have got code issues on them. I don't want to do a bunch of maintenance on houses. I don't want to do all that. The whole time I've been code enforcing, everybody's going, well, you can't own houses. You can't own houses. So I finally started looking at the CAO policy, and it's pretty specific on the jobs titles that cannot own houses. And nuisance control officer is not listed. Code enforcement officer is listed, and that's a job title in code enforcement. Our housing officers, their job titles are code enforcement officers. So, and just looking through it, so I spoke to my supervisor. He looked through it. He says he doesn't think it applies to me as well. My director, who's Cash All Chevy, who's been a supervisor in building inspection for 20 years and became our director about a year ago, a little over a year ago, looked at it. He says he also doesn't think it applies to me as well. But he said it'd probably be best to come down here and speak with you all about it and get your all's opinion on it. There's other things that it allows in here, which I understand why this policy came about and what happened in code enforcement to make it come about. But there's things in this policy that wouldn't even stop. So for instance, I can buy a piece of property and flip it. If I don't live in it, if I take a year to flip it, I can buy that property. So this is set up is what happened with code enforcement is 20 years ago or so, some of them, I wasn't around then, apparently were citing properties, and then they were going out and buying those properties after they've been cited. So I get why they have the policy. The prohibition on owning them doesn't make any sense to me. There's other things that are in place in this policy, like you have to report them, they have to have annual inspections of them, those type things that cover what those officers were doing. So I would think you could still own the houses, but you need to report them and go through the other steps, and I get that. This policy specifically allows me to go buy any kind of house here in town, buy it and flip it. And so you've got that same logic of, well, what's stopping me from buying a house that code enforcement's put into foreclosure and buying it, which is apparently what they were doing 20 years ago. I also think 20 years ago, it was probably a whole lot easier to do what they were trying to do or what they were accused of doing versus today. Everything code enforcement does is done on a program called Salesforce that the law department has access to, and truly anybody can log into it. And you can, see what's going on with it. Anytime you touch something on one of those properties in code enforcement, your fingerprints are on it. So there's so much more transparency and so much more openness about what we do. It's not stuff that's put on paper, that's put in file cabinets and files. The first thing that got me going with it was that truly the nuisance control officer is not even listed in there. The policy's been updated several times. I would think if the CAO wanted that job title put in there, they would have put it in there at the time or when it's been updated. And I don't know for a fact, but I think some of this goes back to at some point in time over in HR, they said, well, if you're an inspector over in code enforcement, this policy falls under you. And maybe nobody looked down into the meat of it and read it to see, well, maybe it doesn't apply to them. So I'm asking to be able to go out and buy 2 or 3 rental properties. Nothing, I don't want to make it a full-time job or any of that type of stuff. I would like to be able to do them in Fayette County. And really more specifically, I live in Masterson, and I would probably gravitate towards buying them in Masterson or McConnell's Trace or that kind of Leestown Road corridor, so that if something happens with the house, I can get over there to it in 5 minutes and don't have to drive to another county to be able to go do it. I know contractors that work here in this county that don't necessarily want to go to Scott County or Jessamine County, so it would just, so that's what I'm asking for.
And to be clear, sir, you are not a code enforcement officer or a fire inspector, correct?
I am not. My job title with the city is a nuisance control officer.
How many job titles are in code enforcement?
Uh,
Is it just code enforcement officer and nuisance control officer, or are there multiple?
No, there's those, yes, and then the supervisors of them, but yes, they're split up. So the code enforcement officers inspect, if you think about the structure on a property, okay, they inspect the houses. They have to take written tests and be state certified to do those inspections. It's the exact same test that building inspection guys take. Nuisance control officers inspect the property itself. So tall grass, indoor furniture outside, that type stuff. But they're 2 specific job titles.
And which department does the nuisance officer fit under?
We work in code enforcement.
There's nothing structural about your sites, about anything that you do. There's nothing.
That's correct.
What kind of nuisances do you deal with?
Mainly tall grass, junk vehicles, indoor furniture outside. Those are kind of the big ones.
Any other questions? I'll entertain a motion to go in closed session to consider this.
So moved.
All in favor? Aye.
Do it again.
Motion to come back into regular session.
About closed sessions.
We got a motion, do I have a second?
Second.
All in favor?
Aye.
Mr. Gayheffer, we've discussed your request. From an ethics commission standpoint, we don't feel like we have the authority to comment upon the CAO policy that you've presented to us. One thing that we can say is is I think that none of us feel that there's a problem right now. I will say this, that in the future, particularly if you are purchasing property in Fayette County that you intend to rent, that has had code violations on it, that could present a problem. But just in general, from an ethics code standpoint, we don't see any prohibition to what you're proposing to do.
Okay, thank you very much.
Okay, next on the agenda, we have complaint 2019-1 and 2019-2. That is Taniqua Latrice Oliver versus Lawrence Weather, Lieutenant Chris Van Brackle, Lieutenant Tommy Perkins, Luann Redcorn, and the separate matter, Taniqua Latrice Oliver versus Timothy Ball. For those of you who are parties, whether that's Ms. Oliver or the various respondents, and your respective counsel, if you have any, please come forward, try to take the seats that you have. Are any folks in the area just witnesses or observers? Okay, if you are just a witness or observer, could you please exit?
Sir, that's a violation of the KRS Open Meetings Act.
No, ma'am, it is not.
On what grounds?
We've got various grounds upon which it is not a violation.
I'm listening.
First of all, we've got various things. Number one, Section 2527 of the LFUCG Ethics Code. Excuse me, wrong code section. We've got an open meetings decision from 2001 from the Office of the Attorney General. We also have
Code of ordinances where it actually defines the code of ordinances. Code of ordinances 25:3 and 4, it says this chapter is intended as a minimum standard of conduct for officers and employees. It does not abrogate any stricter or higher standards established either by federal, state, or local law, including the common law of the Commonwealth of Kentucky and the Code of Ethics of the Lexington, Fayette, Irving County Government Charter, or any rule or regulation established by the Irving County government, an agency, or a constitutional officer. And being that the KRS 61.800 says that any open meetings is open to the public, it does not abrogate that. So I'm sorry, no ordinance that you can name is going to abrogate a state law. So unless you have another state law that mandates this meeting closed, I'm sorry, but I'm not going to take that.
no, ma'am, there is a specific exception under KRS 61.8101C, which 68.8101C allows closed sessions for discussions of proposed or pending litigation. Number one, there is also a provision 61.8101F, discussions or hearings which might lead to the appointment, discipline, or dismissal of an individual employee, member, or student without restricting the employee's, members, or student's right to a public hearing if requested. We have had requests from at least one of the respondents that it should be in closed session. One of those reasons being there's an ongoing criminal matter, which I think needs to be considered.
This is not about the ongoing criminal matter. this is about the conduct and the level of decency that I have been treated by government officials, hence the government official that I have listed within this complaint. And your misinterpretation of KRS 61.81F specifically says at the very beginning, this exception cannot be interpreted to permit discussion of general personnel matters in secret. So I'm sorry, that doesn't fit either.
So, Ms. Oliver, if you disagree with our interpretation, the Ethics Commission intends to have this meeting closed. And if you disagree with that, then the mechanism is for you to file an appeal. But for the purposes of today, the hearing will be closed and anyone who is not a party will have to step out.
I'm sorry, but the same exact exceptions that y'all are trying to use to close this has already been taken to the Kentucky Supreme Court in 2012 with, I believe it was Carter versus Smith. And I believe I actually served this office 3 days ago with a complaint explaining exactly why this meeting cannot be closed, so.
Ms. Oliver?
I'm sorry.
Carter versus Smith, the reason why that exception was not applicable is that related to a resignation. The gentleman in that matter had already resigned. And so what the Supreme Court said is, look, the appointment, discipline, or dismissal was not applicable because it fell outside those 3 items. What you have accused these individuals of could result in discipline.
That means those particular discussions can be in closed session. But as far as my testimony and me giving clarifications of my complaint are applicable for an open meeting.
Ms. Oliver?
It's supposed to be open to the public. I'm sorry, you are violating KRS right now. You are breaking the law.
And our mechanism is to file an appeal.
You are breaking
Ms.
the law.
Oliver, if that is your position and the people with you who are not your attorney, your remedy is to seek an appeal.
And I will do that, but I want to make sure it's very clear. You have this recorded, right? That you all are breaking the law of the Open Meetings Act. All of you are. Is everyone voted on that? Because I mean, I will continue, but I want to make sure everyone is on one accord with this is supposed to be closed, and that y'all all in agreements that y'all all going to violate the KRS Open Meetings Act. Are y'all going to clarify that under recording?
Do I have a motion to go into closed session?
So moved.
Do I have a second?
Second.
All in favor? Aye. Any opposed? Motion carries. We go into closed session. If you are in favor? Aye.
We are recording.
We are back in open session. The next thing on our agenda is a review of the minutes of the May 2nd, 2019 meeting. That was part of the packet that was distributed. Did everyone have an opportunity to read those?
I did. I was one of the absentees, so I don't know that I'm qualified to have any revisions or comments.
I will entertain a motion from someone who was present at that meeting.
So moved.
Do I hear a second? All in favor of approving those minutes? Aye. Opposed? Motion carried. Do we have an update on the financial interest statements from 2018?
Yeah. So at this point, we only have one person that we need a financial interest statement from, and that is Kevin Stinnett. The last correspondence we had was returned to us, so.
Do you want research to find them?
Yeah, we can give him a call.
Okay.
We did come across 2 additional people from past years when going through some files. Deborah Bright, from 2017, the last correspondence sent via certified mail was returned January 11th on 2019. I did speak with Ms. Bright on the phone in June, and she explained that she was under the impression that she didn't need to file one. It was just an error, so she'd been ignoring the letter. So if we send her another one, she's expecting it.
Could we do that, please?
Mm-hmm. And then Karen Mundy, she's current on 2018, but again, from reviewing our files, I found that she did not submit a 2017, and her letter was returned again. So.
Do we have any contact information for her? Other contact?
I think that's what it was.
She's on the planning commission?
I believe so, yeah.
I think it's one.
Yeah.
Yeah, she's current,
Okay.
yeah. It was just oversight.
If y'all could follow up on those for us.
She's still there.
I believe so, yeah.
One thing that is not on our current agenda is scheduling a date for the other preliminary inquiry that came in just a few days ago. I know that I think Abby sent out an email, but received very few responses as to availability.
the derelict people on that front.
Great stuff.
Nobody wants to do it.
Well, this is
I
fun.
can do any of the days.
I said that too.
The next
don't have
week
any other
is, I'm out of town for depositions 2 of those days, and then I've got, that may be tough, probably the only date that it might work would be a Tuesday.
What were the proposed dates, Abby?
It was August 12th through the 19th, I believe, is what those dates were.
So just next week?
Yeah.
Or Monday.
Or Monday, the 19th.
The only date out of those I could do would be the 13th, but obviously if I'm not available, there's no reason to hold the rest of the board
I'm not
hostage.
available. I got 3 trials this week. That's, no.
We'll announce it at the end.
Anything late in the week of August 19th?
I'm out the 21st, 22nd, 23rd.
Could not do Friday, the 23rd.
Okay, what about Friday the 16th?
So I will still be on the road at that point in time, but again, if others are available,
Next week. Next week, but following week.
We just have to have it within 30 days, though.
Yeah.
Yeah.
When was the date that we got it?
Yeah, do you know what the date was filed?
Oh,
You can go into
It's like the 19th of October.
It was close to the beginning of the.
it was just a couple of weeks ago. Yeah, I didn't bring that with me.
Let's see.
You just have to
It's
acknowledge receipt
not
of it
for me, but
Within 10 business days,
Yeah.
which is usually when we.
We have
it's
30 days to have the hearing.
Yeah, and it's. I don't think it's been 10 business days yet. So.
We're nearing that.
Yeah, we're nearing, but we usually put a date on the.
How many people for the 19th?
so
Looks
if
like
you're
a quorum
gonna
to me,
have a quorum, I'd say go ahead.
Is the 19th a Monday?
Yes.
Ah, sweet.
The one suggestion I had before on these.
Mondays and Fridays
if
are
you're
the best.
establishing a date and
My
you don't have a quorum, if we know the parties so that we can know if we have to recuse or not, it can be helpful because if you don't know that until after you fix the date, then if you fall below a quorum, then, so if we, do we know the parties already in this?
Yes, we've received the complaint, and I can email it out
Okay.
to everybody.
It probably won't happen again, but it can if we're on the number.
Sure.
And somebody has to recuse, so
Okay.
it's better before solidifying a date if we can, to know who the parties are, so if anybody would have to recuse, wouldn't count. But saying that, having said that, the 19th is fine for me.
It looks like we got it on July the 30th. And the complainant is Alex Wood. And the respondent is Eric Campbell. Mr. Campbell is a firefighter paramedic.
We go.
Jurisdictional problems. Yeah, let's see if we can get that settled next time.
So we're going with the 19th, 5:30?
Yes.
Excellent.
Any new or old business?
That's,
I will entertain a motion to adjourn.
So moved.
Do I hear a second?
Second.
All in favor?
Say aye.
Bye.